Good evening, everybody. Keith here. Hoping everybody had a good day, enjoying life, living life, loving life. Wanted to talk to everybody tonight about contracts and jurisdiction. First, I want to mention real quick about contracts. I did a video earlier today about the SS5 application and doing some correction on that in regards to authorized representative. And in that video, you'll notice I also mentioned UCC 3-402 subsection B subpart 1, wherein it states that the one giving an authorized signature as the authorized representative on the instrument is not liable for the person named in the instrument. And I made a note on that in regards to the SS5 application, which is an application for a Social Security card or a correction thereof. And in that correction, we're going to fix the status of the citizen as well as the name. And the very last thing mentioned on the application, which is in regards to self or the natural being, or mom and dad, parent, whatever, which are not qualified as a person. They are not the same thing, so you cannot possibly claim self as the person or the natural being as the person, as one is a live being and one is a fictional character known as a person. And so on that, in regards to that, you mark other. There's a legal representative or other, and it is suggested by myself that you mark other and then put authorized representative, and that is your qualification for non-liability in regards to contracts. And so now I've got a couple pages here I'm going to read in regards to jurisdiction and unlimited power to contract. And the first one we're going to start out with is American Jurisprudence, 2nd, 1964, volume 16 at 373. And it says rights of contract. And it says liberty of contract involves as one of its essential attributes the right to terminate contracts. Valid contracts are property, as one of its and as such are protected from being taken without just compensation. And again, I iterate, these are very important words and terms that we need to comprehend. The United States Supreme Court has stated that freedom to contract is the essence of freedom from undue restraint on the right to contract. Other courts have stated that the liberty to make contracts includes the corresponding right to refuse to accept a contract or to assume such liability as may be proposed. The right of liberty of contract is inherent, and this says inalienable, because when we're signing these contracts, we're signing in the capacity of a citizen, which again is a person, a fictional person. So they use inalienable, the word or term inalienable, whereas the live being has unalienable rights. And so when we talk inherent and inalienable, it's talking about privileges, which are a lower format or lower level of rights. They are granted by those that have rights. It belongs to every citizen by the law of the land. Every man has the right freely to deal or to refuse to deal with his fellow man. And that can be located at page 706 to 707 in that American Jurisprudence. And then the next one is, and it's got a case here, And this is as I got involved in a conversation on my earlier video. When you use case law is known as black letter law. And when we talk about black letter law, we're talking about color. You have black letter law, you have blue letter law, you have red letter law, and you have purple letter law. And there's a reason for those colors. We'll discuss that at a later point in time. But it says jurisdiction can be challenged at any time and must be proven, not assumed. And the case law here is Basso, B-A-S-S-O, versus Utah Power and Light Company, 495, comma, capital F, space 2, lowercase d, 906, excuse me, space 906, space 910. The next one is the court must prove on and for the record all jurisdiction facts related to the jurisdiction asserted. And when we're talking about all jurisdictional facts, we're talking about 7 different elements of jurisdiction, starting with personal jurisdiction. In other words, that personal jurisdiction, the authorized representative must be proven on and for the record. And that case law is Latana, L-A-T-A-N-A, versus Hopper, H-O-P-P-E-R, space 102, space 2, lowercase d, space 188. And then it says, it's also got another case, Chicago versus New York, 37, space, uppercase F, space, uppercase S, uppercase U, uppercase P, space 150. And I'll post pictures of this when I'm done. I'll go ahead and edit the post. The next one is a judgment rendered by a court without personal jurisdiction over the defendant is void. And it says, again, comprehend the English words, over the defendant, telling you that you are not the defendant, but you have personal jurisdiction over the defendant. It is a nullity. And that case law is Joyce versus U period S period space 474 space 2 capital D or uppercase D space 215. And from here on out, there's a lot of things that's going to include spaces and commas. So I'm not gonna worry about that. I'll just go ahead and post the pictures. Like I said, I'll edit the post. The next one is a judgment shown to be void for lack of personal service on the defendant is a nullity. And when we talk about personal service on the defendant, we're talking about diplomatic channels of notice. And this is specifically in regards to the Code of Federal Regulations 93.1. And that's where the prosecution plaintiff has to give diplomatic notice to the United States Department of State that they have filed a claim or complaint against the person known as the defendant. Then the United States Department of State has to give notice to the authorized representative who has personal jurisdiction over the defendant. And this is why personal jurisdiction is the first element of jurisdiction and must be proven on and for the record. If they do not do this, none of the other 6 elements of jurisdiction even applies. This has to be done first. Everything is mathematical. So, and that is Sramek versus Sramek, and that is S-R-A-M-E-K versus S-R-A-M-E-K. And I can only imagine that this is in regards to two parties that were involved in maybe a divorce settlement or something. 17 Can APP 2D 573 576 to 77 840P 2D 553 1992 reversed and denied 252 Can 1093 1993. So it was appealed in 1992 and reversed in 1993. Says a court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is a clear and well-established law that a void order can be challenged in any court. Old Wayne MUTL Associates versus McDonnell 204 U.S. 827 SCT. Thus, where a judicial tribunal, and that's a judicial tribunal, we're talking about a state court case here. So when we talk about judicial, it is still a corporate venue. So judicial is only referring to the state judicial rather than the congressional judicial authorities. Thus, where there is a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act. Its proceedings are absolutely void in the fullest sense of the term. This is Dillon versus Dillon. Then the next one, if any tribunal, and this says court, and we know courts are corporate entities. So any tribunal, court, finds absence of proof of jurisdiction over a person and subject matter, the case must be dismissed. See also Louisville versus Motley, 1907. The laws of Congress in respect to those matters do not extend into the territorial limits of the states. So the territorial limits of the states, again, are corporate, but have force only in the District of Columbia and other places that are within the exclusive jurisdiction of the national government. Okay? Again, the national government is a corporation, and that's why it exists in District of Columbia. And that is Caja versus U.S. And Caja here is all capital letters. Which shows that it's corporate. When a tribunal claims to have jurisdiction, and I mean the opposing party was giving full and whole disclosure to the matter, which they were not, and a decision is imposed by that tribunal, it is void. That's, of course, if you challenge it right. And that shows a case reference, Elliott versus Pearsall. This one had no jurisdiction, and that is from 1828. And it still stands on and for and in the record. This is congressional record. The people of the state are entitled to all rights which formerly belonged to the king by his prerogatives. That is Lansing versus Smith. Again, 1829. Long-standing cases. And when we talk about rights that formerly belong to the king, we're talking about sovereign powers. You are not a sovereign. You have sovereign powers. A sovereign is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right, which is a privilege, as against the authority that makes the law on which the right depends. and that is Kawananaka versus Polyblank. That's 1907. And I'm not going to attempt to pronounce that again. Like I said, I'll put pictures of this up. And then it goes on. The next one is a general rule that sovereign cannot be sued in his own court without consent, and hence no direct judgment can be rendered against him therein for cost, except in the manner and on the condition he has prescribed. So again, if he prescribes a privilege and they want to assert they have a privilege to sue you in your court of rights, they cannot do that. They have to stand in their own rights. In other words, as a man and not as a fictional person. So they cannot assert personal jurisdiction. Okay, comprehend that one. Let's see. And that is Bouvier's Law Dictionary, Volume 1, 1897. The next one is sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign authority is delegated to agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And this is one of the very prolific cases, Yik Wu versus Hopkins. Okay. Then the next one, we're going to go back to Basso versus Utah Power and Light Company, which I mentioned first. It says jurisdiction can be challenged at any time, and jurisdiction once challenged cannot be assumed and must be decided. Before it said cannot be assumed. This one says and must be decided. The next one is Cannon versus Commission on Judicial Qualifications. Remember, we spoke about qualifying that signature as authorized representative, fixing that Social Security application so you can qualify that signature. And it says, acts in excess of judicial authority constitutes misconduct, particularly where a judge deliberately disregards the requirements of fairness and due process. Then the next one is Elliott versus Pearsall. Again, we mentioned this one. Under federal law, which is applicable to all states. This is why all states have the Uniform Commercial Code. This is why this immigration thing, they're all passing these immigration laws in regards to keeping the foreigners out of our nation, securing the borders. The states are trying to pass that in uniform, and they must abide by federal legislation first in order to pass it under their state laws. And then once all 2/3 of the state pass it, they can present it to the federal government for re-legislation of immigration laws. It's the only way they can do this, which is applicable to all states as the U.S. Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. So at this point, these states that are passing these immigration laws, they are nullities. They are only a conjecture at this time so that they can continue to try to get the other states to pass the same kind of legislation so that they, again, can present it to the federal government for re-legislation. They are not voidable, but simply void. They are already void, so they are not voidable in a future tense or an active tense. They are at present void, and form no bar to a recovery sought even prior to a reversal in opposition to them. So if they're going to try to charge you with some kind of immigration violation and then change the law later on and try to say that they're going to change the law here, we're passing the laws, it's void. It doesn't matter. Period. They constitute no justification, and all persons concerned in executing such judgments or sentences are considered in law as trespassers. So let's read this again. They constitute no justification, and all persons. Okay, remember, persons are a fiction. They reside inalienable rights, which are privileges we have granted upon them, and therefore concerned in executing such judgments or sentences are considered in law, not at law, as trespassers. And then the next one is Gonzalez versus Commission on Judicial Performance. 1983, acts in excess of judicial authority constitutes misconduct, particularly where a judge deliberately disregards the requirements of fairness and due process. So we have a second case that reiterates where a judge deliberately disregards the requirements of fairness and due process. The next one is Hilltop Developers versus Holiday Pines Service Corporation. Defense of lack of jurisdiction over the subject matter may be raised at any time, even on appeal. Then we're going to reiterate the Joyce versus U.S., where it says there is no discretion to ignore the lack of jurisdiction. And again, we're going to reiterate Latana versus Hopper. Let's see, court must prove on the record all jurisdiction facts related to the jurisdiction asserted. So again, we have to comprehend that they have to assert personal jurisdiction first. And in order for them to assert any other jurisdiction, in this regards it says, prove on the record all jurisdiction facts related to the jurisdiction asserted. They have to be able to show that they have personal jurisdiction by giving diplomatic notice to the United States Department of State under Code of Federal Regulations 93.1, and then the U.S. Department of State has to give the authorized representative notice that somebody's filed a claim against their person. Then in 93.2 of the Code of Federal Regulations, they are required to prove that they have filed a claim against the defendant and that the defendant is a corporate person. Comprehend this stuff, people. Do your research, and I'm giving you all kinds of information to research on. Maine versus Thibodeau. The law provides that once state and federal jurisdiction has been challenged, it must be proven. This clarifies that the state and federal jurisdictions they assert are corporate jurisdictions of a person. No court of a state and no court of a federal government can have personal jurisdiction over the man. The man has a right to contract for his person, period. Malo versus U.S. Again, this is another very well-known case. Once jurisdiction is challenged, the court cannot proceed when it clearly appears that the court lacks jurisdiction. And they lack jurisdiction because you are the only one that gives a signature, period. And that signature is presumed to be authorized and to be given by the authorized representative. That's why they can't sign documents for you. Period. So when it clearly appears that the court lacks jurisdiction, the court has no authority to reach merits, but rather should dismiss the action. And I say that rather must dismiss the action, like the previous case said. Then we have Norman versus Zyber. In regard to courts of inferior jurisdiction, if the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. Okay, and this goes back to these other cases we just talked about where the judge deliberately disregards the requirements of fairness and due process. Then the next one is Norwood versus Renfield. Ex parte Giambonini. A universal, and understand ex parte, Norwood versus Renfield, and then it says ex parte Giambonini. Ex parte is they acted solely on the part of Giambonini and not in regards to Norman versus Zyber. Strictly in a one-sided decision. One-sided decision on the behalf of the ex parte party, Giambonini, and not in regards to Norman versus Zyber. I can only imagine that was a what's called a curé of the court, a friend of the court. Anyway, it goes on to say a universal principle as old as the law is that proceedings of a court without jurisdiction are a nullity and its judgment therein without effect either on person or property. And that's what the ex parte is all about. It says its judgment therein is without effect either on person or property. And what that's saying is that the ex parte party, Giambonini, gave judgment because he brought it as his inherent unalienable right as a man to make the decision for the court on behalf of the case of Norwood versus Renfield. If you have any questions on that, private message me. I'll try my best to help explain that further. And then it says Rescue Army for the next case, Rescue Army versus Municipal Court of Los Angeles. Comprehend Municipal is a corporation, and it is the highest corporation in regards to the local jurisdiction when it comes to custom. It is custom to that local area, and therefore that has the highest jurisdiction generally. When we speak of our municipalities, we have what's known as county courts, and they have the county registrar. The registrar is where they generate the original informations that are recorded, and that is your greatest jurisdiction. But again, in regards to customs, it's the municipals. In regards to legal systems, it's the county seat. Let's see here. A court has no jurisdiction to determine its own jurisdiction for a basic issue in any case because a tribunal is its power to act, and a court must have the authority to decide that question in the first instance. Okay, any court has a power to act, but it has to have the authority given to it, period. And that has to be done through some kind of contract. All these courts are commercial courts, and they have to have a contract conferring that jurisdiction, the right of enforcement. That comes from your federal government through your executive, judicial branches of legislation. In order to grant right of enforcement, it has to generate from the Senate. Okay, the House of Representatives, like I spoke on in one of my previous videos, they have the only right to institute laws in regards to money, monetary systems, and currencies. It has to generate out of the House, and the laws that generate out of the Senate are in regards to at-laws and in-laws, legal and law, not your money systems. Okay, Rosemond versus Lambert. The burden shifts to the court to prove jurisdiction. I don't have to prove jurisdiction. It is already proven by my presence. You can see that I'm an adult, that I can discern for myself. So when we talk about age of majority, I hope people will comprehend this. You are not a majority. You are the minority. As an individual man, you carry your own jurisdiction, and that is the highest jurisdiction, period. And you can present that in court by your physical presence. And they can see, I am an adult. They cannot question that. It has already been discerned. And as long as I am of sound mind and body, and that's where the body comes in, the presence of the body cures the ear in the name. Okay, they can see that I'm a man and not a person, and that I'm an adult, and I am in the age of discretion. I can discern for myself. Comprehend the English language and correct this shit. It is not, in my opinion, age of majority. It is age of discretion. Telling them and reaffirming that you are of sound mind in body, and body, of body. Okay. Ryan versus Commission on Judicial Performance. Before sending a person to jail, that's a funny one. I will wrap my birth certificate up as the person and hand it to him and tell him, cuff him. Cuff him. But hold on tight because he might fall out. I love words. Anything you say can and will be used against you in a court of law, and damn right I'll use them against you, motherfuckers. Before sending a person to jail for contempt or imposing a fine, judges are required to provide due process of law, not legal process, due process of law, including strict adherence to the procedural requirements contained in the Code of Civil Procedure. Ignorance of these procedures is not a mitigating but an aggravating factor. Aggravating means criminal. And again, we're going to go back to the case before, Sramick versus Sramick. It says, a judgment rendered by a court without personal jurisdiction over the defendant is void. It is a nullity. A judgment shown to be void for lack of personal service on the defendant is a nullity. And then we go to the next one, Stuck versus Medical Examiners. Once challenged, jurisdiction cannot be assumed. It must be proved to exist. So there's another case that says the identical statement. U.S. versus Anderson. Jurisdiction of court may be challenged at any stage of the proceeding, and also may be challenged after conviction and execution of judgment by way of writ of habeas corpus. Okay, this is an interesting one for myself because I've already been convicted, served the sentence, and the judgment can be challenged by way of writ of habeas corpus. Why? Because they have asserted that they have jurisdiction over me, and they will try to continue to assert that jurisdiction, which is a criminal act in continuance. They are continuing to act in criminal behavior against myself. And I am blameless. And I can prove it. Okay. U.S. versus Gurney. In a criminal proceeding, lack of subject matter jurisdiction cannot be waived and may be asserted at any time by collateral attack. This is where we talk about the Clearfield Doctrine. When a commercial court presenting itself as a judicial court makes any action against a live man, they have lowered themselves, and this is only, I only say this because it's stated in the Clearfield Doctrine. They lower themselves to that of a private citizen. They haven't lowered themselves to the status of a private citizen. They are already in the status of a private citizen because they are acting as a private citizen, doing corporate acts, and therefore they are a private citizen already. They have not lowered themselves. They are already in that position. Okay? And so when it says they cannot be waived and may be asserted at any time by collateral attack, means you can collaterally sue them in both personal and private capacities. What that means is you can use your Admiralty Maritime courts. And this is why I say don't be afraid of those courts. Use them, learn them, and know how to use them. You can now collaterally attack them because they have committed an act of what's known as mixed war against one of the people and used his person against him. Okay? So you can now collaterally attack them and go for their, quote, property and wipe them off the face of every document that exists. You can clear out that account. Why? Because they actually have no value anyway. It's all fiction. So what you do is you assert your common law right to lawful coin, and everything they own cannot possibly equal the value of one coin that you hold in your pocket. Because everything they own is dependent upon a Federal Reserve note, which is known to have zero value. So take them all. Every last fucking one of them. Okay, then the next one. U.S. versus Lopez and Hagens versus Levine. Now, I use Hagens versus Levine in my case, and of course was railroaded again, just like everybody else. But it's a learning process. Both void because of lack of jurisdiction. In Lopez, the circuit court called it right, and in Hagens, it had to go to the Supreme Court before it was called right. In both cases, void. Challenge jurisdiction and motion to dismiss right off the bat. Because if you read the Supreme Court cases, you will find that jurisdiction can be challenged at any time. And in the case of Lopez, it was a jury trial, not a trial by jury, but the lower jury trial, which was declared void for want of jurisdiction. Remember, the jury trial, when they present these cases, even if they try to charge you with a criminal act, it's a jury trial, which is a civil grand jury. It's a contracted grand jury. And we know this because they pay the jury members to sit on the jury. They're compensated. That's a contract. It's a civil grand jury. Unlawful. And that's why it's void. So when I did mine, I preferred not to get the common people involved in a contract that they know not what they do. And I shall not perish for lack of knowledge. So I'm going to ask to prove all things. And I'm going to hold the one man liable. And that's that motherfucker sitting in that black clown suit. And all of his partying friends. So anyway, it says, if jurisdiction doesn't exist, it cannot justify conviction or judgment without which power the state cannot be said to be sovereign. See, the state is claiming all this sovereign shit, and they're not even fucking real. The man gets his sovereign powers from the sovereign being that granted those sovereign powers of dominion. Dominion of the land, air, and water. LAW. Man is law. He is the steward. He is the house ward. STE ward of his house. He is not a ward of some fictional state who claims sovereign power over him. Fuck the state. So, if jurisdiction doesn't exist, it cannot justify conviction or judgment, without which power the state cannot be said to be sovereign. At best, to proceed would be in excess of jurisdiction, which is well fatal to the state's, USA's cause. They don't have cause to begin with. You cannot cause loss or harm to a fictional entity. It doesn't exist. You cannot rip up a Federal Reserve note and cause harm. Rip them up if you want. Fuck that federal statute. Fuck that fucking IMF, International Monetary Fund. Learn where you stand. Let's see here. Broom versus Douglas. The same jurisdictional facts fatal to the government's cause. U.S. versus Rogers. The question of jurisdiction in the court, either over the person, the subject matter, or the place where the crime was committed, can be raised at any stage of the criminal proceeding. Notice, they never say the man. Why? Because they can't claim a crime against the man, because they can't suffer a loss or injury. Comprehend the language, people. Okay. It is never presumed, but must always be proved. And it is never waived by the defendant. Never. And it states it right there in their own fucking case. It is never. And it gives no reason why it could be waived or why it might be waived. It just says it is never waived by the defendant. And again, they use the wrong word or term here. By the man is what it should say. And it should say the man because the man has unalienable rights. Like I said earlier, the man has unalienable rights, and the person who is under the man has inalienable privileges. And those he can waive. You can waive that SS5 form. You can waive the tax forms. You can waive the medical bills. You can waive your utility bills. You can waive the charge for buying a new car. It's called a letter of credit. We're working on that. Justin Nolan's almost got it tweaked. Randy, what's his name, and Heather Ann Tucci Giraffe did it wrong. They went out and got a bunch of Federal Reserve notes and tried to pay it with Federal Reserve notes. You can't do that. You got to use a letter of credit, correcting their error on where the credit comes from originally. From myself. From you. From yourself. From the man, the woman. Okay. Then we have Woost versus Woost. W-E or W-U-E-S-T. ST versus WEST. A departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form in method of procedure, which has the effect of depriving one of constitutional right, is in excess of jurisdiction. And what we're talking here, people, is letter of law. Remember I said earlier case law is black letter law? It's what's written down, and never will you see it in blue, red, or purple. It will always be in black, and that's why they call it black letter of law, and it is called literal law. It is the literary, it is the written down law. Whereas the substance of law in every criminal case must contain this element first. Again, like I said, it's all mathematic. This element first, and that is intent. If you make an error, there is no intent. Your intent could be good, and you're traveling along and you crash into somebody. Your intent may not be to crash into them, but you did. That is not a crime. That is an error. That is accidental. It was a mistake. It can be corrected. You still need to compensate for that loss out of honor and fairness. You caused it by your own mistake. To not stand in honor and compensate for that loss would be a crime. It would be intent after the fact. But a man must always stand in honor. And this is why we settle matters outside of court. We don't need these courts. We don't need insurance. You can get surety bonds. You can put $1,500 up for a surety bond for 3 years. That covers the $15,000 required to cover most damages. Period. And that is good, honorable intent. And I suggest people learn this stuff. Insurance means in surety. It's putting yourself in surety. You don't want to be in surety. You want to put your person in surety. Okay. Next one. Let's see here. I've just got a note here. It says driver applicant means an individual who applies to a state or other jurisdiction to obtain, transfer, upgrade, or renew a CDL, or to obtain or renew a CLP. Commercially licensed practitioner. Driver's license means a license issued by a state or other jurisdiction to an individual, which authorizes the individual to operate a motor vehicle on the highways. So now we're going to go to, I've got a note here, but I can't remember. I've got a number. I'll have to look it up and see if I can post a link to it, but it's 321.561. And it says punishment for violation. Violation. It shall be unlawful for any person. Again, we're talking about persons, so this is a civil code. Found to be a habitual offender to operate any motor vehicle in this state during the period of time specified in Section 321.560, except for a habitual offender who's been granted a temporary restricted license pursuant to Section 321.215, subsection 2. A person violating this section commits an aggravated misdemeanor. Okay? Now, we're going to talk about that license. The motor vehicle or motor vehicle operator leases. That's what a license is. It's a lease. It's a lease agreement. And why is it a lease agreement? Because you registered your car. On one side of the books, you registered the car with the Treasury, the Secretary, the county treasurer, and on the county treasurer's side, they made an acquisition. They acquired an object, and they termed it as a motor vehicle now. The thing is that motor vehicle operator's lease is placed in the IRS code, Title 26 of the United States Code, Section 7701, subsection H. And I posted on this many times. And it's a motor vehicle operator's lease, which is dependent upon many things. One of which the state asserts is a statement under penalty of perjury that you intend to use the motor vehicle at least 50% of its use for trade or business. And again, trade or business is a corporate term in accordance with public or government employment. Okay, now if you've never filled out that statement under penalty of perjury, then there is no statement under penalty of perjury validating the motor vehicle operator's lease. Okay? So, they have a section down there at the very bottom that states that the lessor must not know that the certification is false. What's the certification? Well, when you register the automobile, the treasurer acquisitions it as a motor vehicle, and when they show the state that they've acquired a motor vehicle, the state then issues a certificate of title. That's the certification. And all you have to do is rebut that one title, that one section of that title, by stating that the certification is false. And you can prove the certification is false many ways, because there is no record that you signed a statement under penalty of perjury willingly, knowingly, and intentionally, unless you read it somewhere and agreed to it knowingly, willingly, and intentionally, as well as if there's a lease providing for commercial activity for taxation purposes, there must be records showing the commercial activity. In other words, like a commercial driver's license, the CDL. As I stated here in the last part, driver's license means a license issued by a state or other jurisdiction to an individual which authorizes the individual to operate a motor vehicle on the highways. However, a CDL is a certified driver's license, or a commercial driver's license, whereas a driver's license is dependent upon a resident. They don't say resident, and they don't put RDL, they just put driver's license. Again, some confusing factors. So, do they have time logs showing how many hours you were on the road, that you drove it at least 50% of its use? Do they have mileage? Do they have bills of lading showing that something was shipped from a supplier to a customer with an invoice showing what was shipped, when it was shipped? Do they have the receipts for all of this? No. So they have no records showing any of this. There is no such record. They have no proof. It's called no-till record. NULTIEL. No-till record. Period. And once you people comprehend this stuff, it's so easy to just walk in the Word. That's how Jesus walked on water. He didn't literally walk on the top of the surface of water. We're talking about admiralty here. Mercantile law. Law of the sea. And he was able to walk on top of them because his jurisdiction rode above it. As a man over the person. When you hold a piece of paper up, which is the person, and you set it down, can it stand? No, it falls over. It has no standing. Funny how that works, huh? So drop that motherfucker on the ground and walk on it. Stomp right on. Put your footprint on that motherfucker. Fuck that birth certificate. It's a person. It has no standing. So anyway, comprehend this stuff, people. And remember, if it wasn't for you people, I wouldn't be doing this. God bless you. Love you. Have a great night. Bye-bye.